14 days. That is exactly what you have. From the moment a judge signs your temporary order, you have exactly 14 days to build a case strong enough to protect you for 2 full years. In the Washington, D.C. court system, that brief 2-week window is literally the difference between a temporary stopgap and the long-term solution.
Welcome to this explainer. Look, navigating the D.C. court system's protection orders in 2026 is a highly consequential process. Think of me as your guide today. As someone who has been around these courtrooms, I've seen exactly what goes right when people are prepared and exactly what goes wrong when they wait too long or just show up unorganized. We're going to treat this 14-day window with the calm, strategic focus it requires, and I'll walk you through exactly how to navigate it without the panic.
Here is our roadmap for today. We'll start with the initial emergency, move on to that critical 14-day clock, cover building your case, detail the hearing process, and finally, wrap up with securing long-term protection. Okay, Section 1, the initial emergency, where immediate safety absolutely comes first. In D.C., you're essentially working with 2 distinct tools here. First up is the TPO, or Temporary Protection Order. It's an immediate 14-day emergency stopgap. Then you have the CPO, the Civil Protection Order. This right here is your permanent goal, an evidentiary order that lasts up to 2 years. Your objective, always, is to successfully bridge the gap between the two. Now, when you request a TPO, the judge issues this ex parte, meaning the other person isn't even in the courtroom. You simply present your situation to a judge, and if they see immediate endangerment, they grant the order that exact same day. It gives you immediate safety, and, crucially, it kicks off that 14-day clock. Even though it's a temporary fix, the relief you get is substantial. You're looking at stay away and no contact orders, and you can even secure temporary custody of your kids. Plus, here's a massive point for 2026. D.C. law now makes firearm relinquishment mandatory. If the judge signs that TPO, the other party has to immediately surrender all firearms to the Metropolitan Police Department. No exceptions. Moving right along to Section 2, the 14-day clock. This is your strategic window. Let's visualize this timeline so you see what we're up against. Day 1, your order is issued. By day 14, you're sitting in a hearing for your 2-year CPO. Every single day in between has to be utilized. You cannot spend this time just waiting around. You have to spend it preparing. And here is the biggest hurdle you're going to face on this timeline: service of process. See, the full hearing cannot happen until the other person is officially served with the court papers by law enforcement or a process server. Do the real-world math here with me. If it takes 10 days to locate and serve them, you are left with exactly 4 days to prepare your evidence for trial. That is exactly why you have to act with organized urgency right from day 1. Section 3. Building your case and preparing for trial. To get a 2-year protection order, the judge has to find good cause based on a preponderance of evidence, which just means it is more likely than not. You don't have to prove your case beyond a reasonable doubt like you see in criminal trials on TV. You really just need to show that it is more than 50% likely that a criminal offense occurred or was threatened. So how do you actually prove that? Well, in 2026, documentary evidence is absolutely your most powerful tool. We're talking text messages, emails, and voicemails with clear timestamps and metadata. Don't edit them, just provide the full context. Add physical evidence to that, like photos of injuries or property damage, and witness testimony from police or neighbors who heard an altercation. Organization is everything. Judges want a chronological timeline, not a scattered, chaotic box of papers. And this highlights a trap I see people fall into constantly. A very common mistake is spending your limited hearing time describing an unhealthy or toxic relationship. Under D.C. law, a protection order requires proof of specific criminal conduct, things like assault, threats, stalking, or property destruction. Framing your evidence strictly around these specific acts rather than emotional generalities is what actually wins cases. All right, Section 4, the hearing process and actually securing that CPO. Now here's a reality check about what actually happens down at the courthouse. 70% of protection order cases, they actually resolve before a trial even begins. Here is the standard 2026 procedure. Step 1, you'll meet with a court-appointed attorney negotiator who shuttles between both parties to see if a settlement can be reached. Step 2, if the other party agrees, you get a consent order without a trial. If they don't, well, you proceed to a full evidentiary trial. Step 3, expect this to happen remotely. Most D.C. protection order hearings now occur via WebEx, which means all your evidence needs to be cleanly organized and pre-uploaded to Box.com well before your hearing even begins. If you do end up going to trial, keep this checklist in your head. Judges are looking for an organized, chronological timeline. They want specific facts, not vague accusations. They want direct answers to their questions. And above all else, they're looking for a calm, credible demeanor. Just take a breath and let the objective facts of your evidence speak for themselves. Finally, Section 5. Long-term protection and securing your future. A successful civil protection order grants you up to 2 full years of legal protection. It provides a baseline of stability, allowing you to actually plan your life without living under the constant shadow of immediate danger. But you've got to understand, a CPO is so much more comprehensive than that 14-day temporary fix. A judge can mandate child support, order reimbursement for property damage or medical expenses, and even require the other party to attend psychiatric or domestic violence counseling. And if visitation is granted, it can be strictly managed. For example, D.C. has a supervised visitation center that uses staggered arrival times and completely separate entrances, so you never, ever have to interact with the other party during child exchanges. And the protection doesn't magically have to end at the 2-year mark. But you do have to be proactive. First, monitor your expiration date closely. Second, file a motion to extend at least 30 days prior to that expiration. If you file before it expires, your current order stays in effect until the judge rules. Third, you just have to show good cause, meaning you demonstrate that threats have continued or the order was violated, making continued protection absolutely necessary. And that brings us to our core takeaway for this explainer. The 14-day window between a temporary protection order and a civil protection order is your strategic preparation time. It is literally the difference between a strong case and a missed opportunity. When you treat that brief window with calm, organized urgency, you don't just secure a piece of paper, you secure your peace of mind. So the question I want to leave you with today is this. If your 14-day clock started right now, is your evidence organized well enough to tell the facts clearly, logically, and undeniably? Thank you for walking through this explainer with me. Stay informed and stay focused.